Are you a parent living in the United Kingdom, but you are not a British citizen yourself? Have you recently had a child here, or are you planning to, and find yourself asking the crucial question, is my child automatically British? It's a question surrounded by a lot of confusion and misinformation, and the answer is more complex than a simple yes or no. In this video, we are going to get straight to the point and break down everything you need to know about how a child born in the UK to non-British parents can become a British citizen. We'll cover the rules as they stand heading into the year 2025, the different pathways available, the costs, and the critical steps you need to take. This is your comprehensive guide, so let's get started. First, we must address the biggest misconception. Many people believe in something called jus soli, or right of the soil, which means anyone born in a country is automatically a citizen of that country. While this is true in some nations, like the United States, it has not been the case in the United Kingdom for a long time. The rules changed significantly with the introduction of the British Nationality Act of 1981. Since January 1st, 1983, being born in the UK does not automatically make a child a British citizen. Instead, a child's right to citizenship at birth is directly linked to the immigration status of their parents at the exact time the child is born. So, if your child was born here, the first thing to do is not to assume they are British. You need to look at your own status. This leads us to the most straightforward scenario. A child born in the UK is automatically a British citizen from birth if, at the time of their birth, at least one of their parents is a British citizen. That's simple enough. But what if neither parent is British? Well, the child is also automatically British at birth if, at the time of their birth, at least one parent was settled in the United Kingdom. This is the key word, settled. So what does the Home Office consider to be settled? Settled status means that the parent has the right to live in the UK permanently without any time restrictions. This includes a few main categories. Firstly, a parent who holds indefinite leave to remain, often called ILR. Secondly, a parent who has been granted settled status under the EU settlement scheme. This is very important for many European nationals and their family members living in the UK. And thirdly, an Irish citizen who is resident in the UK is also generally considered settled for this purpose. If you or your partner held one of these statuses on the day your child was born in the UK, then congratulations. Your child is a British citizen by birth. They do not need to be registered or naturalised. You can, and should, apply directly for their first British passport. The evidence you will need to provide with the passport application will be the child's full birth certificate, along with clear proof of your settled status at the time of the birth, such as your indefinite leave to remain card or your EU settlement scheme status letter. But what happens if neither parent was British or settled when the child was born? This is where the majority of families find themselves, and it means citizenship is not automatic. But do not worry, there are still clear pathways to citizenship for your child. These pathways require an application to register the child as a British citizen. This is a very common and important route. Let's say your child was born in the UK while you and your partner were here on temporary visas, like a skilled worker visa or a student visa. At the time of birth, your child was not British. However, let's imagine that a few years later, you successfully apply for and are granted indefinite leave to remain or settled status under the EU settlement scheme. The moment you become settled, your UK-born child gains an entitlement to be registered as a British citizen. This is not automatic. You must actively apply for it. The application is made using a form called Form MN1. Once the application is approved and you receive the certificate of registration, your child is officially British. This is a crucial right for your child, and it can be exercised at any point before they turn 18. It's a direct result of your own journey to becoming settled in the UK. Now, let's consider a different scenario. What if the parents never become settled in the UK? Perhaps they remain on long-term visas, or their circumstances are complex. There is another powerful entitlement for the child based on their own connection to the UK. If a child is born in the UK and lives here continuously for the first 10 years of their life, they have an entitlement to register as a British citizen. This right exists regardless of their parents' nationality or immigration status. It is a right based entirely on the child's own life and residence. There are a couple of important conditions. The child must have lived in the UK for the first 10 years of their life. The Home Office also has a rule about absences. During that 10-year period, the child should not have been absent from the UK for more than 90 days in any single year. You will need to provide substantial evidence to prove this continuous residence, such as school records, doctor or GP letters, and other official documents that span the entire 10-year period. Once the child has completed their 10 years of residence, you can apply to register them as a British citizen. Again, this is an entitlement, meaning that as long as the conditions are met, the application should be granted. This is a vital safety net that ensures children who have grown up in the UK and know no other home have a clear path to citizenship. So, you've identified that your child is entitled to be registered. What is the actual process? For most of these routes, including the one where a parent becomes settled or the 10-year residence rule, the application is made online using Form MN1, which stands for Registration of a Minor under 18 as a British citizen. You will need to gather a significant number of documents. This will always include the child's full birth certificate, the parents' passports, and proof of the parent's immigration status. If you are applying based on the 10-year rule, you will need that decade's worth of residence evidence we discussed. If you are applying because you recently became settled, you'll need your ILR or settled status confirmation. A very important point is the Dutch character requirement. This applies to any child applying for registration who is aged 10 or over. The Home Office will assess whether the child is of good character. For most children, this is not an issue. It generally relates to things like a history of criminal convictions or other behavior that the Home Office deems undesirable. Now, let's talk about the cost, which is a major consideration for many families. As of late 2024, the application fee for a child's registration using Form MN1 is £1,214. This fee is for the application itself and is non-refundable, even if the application is refused. It is also important to know that these fees are reviewed by the Home Office regularly, usually every year, so you must expect this figure to change for 2025. Always check the official government website for the current fee before you apply. Furthermore, if the child is approaching their 18th birthday when the application is approved, they may be required to attend a citizenship ceremony. There is an additional fee for this, which is currently £80. Processing times can vary, but you should typically expect to wait between 3 to 6 months for a decision, though sometimes it can be longer depending on the complexity of the case and Home Office workloads. Once your application is successful, you will receive a certificate of registration. This document is the official proof that your child is now a British citizen. It is a critically important document that you must keep safe. With this certificate in hand, your child is not automatically issued a passport. The certificate of registration is the key that unlocks the final step. You must now take this certificate and apply for your child's first British passport, just as any other British citizen would. The passport application is a separate process with its own form and its own fee. So, to summarise the key points for 2025, first, birth in the UK does not automatically grant citizenship. It depends on your parental status at the time of birth. Second, if at least one parent was British or settled with indefinite leave to remain or EU settled status when the child was born, the child is British automatically. You can apply directly for a passport. Third, if you were not settled at the time of birth but become settled later, your UK-born child has an immediate right to be registered as a British citizen. You must apply for this. And fourth, if a child born in the UK lives here for their first 10 years, they gain their own right to be registered as a citizen, regardless of their parent's status. Navigating the UK's nationality law can feel daunting, but the rules are logical. The most important advice I can give you is to always refer to the official source. The gov.uk website has the most up-to-date application forms, guidance notes, and the current fees. Things can and do change, so please, before you spend any money or submit any forms, double-check the official guidance. I hope this video has clarified the path to British citizenship for your child. It is a journey that requires careful attention to detail, that for many, it leads to securing your child's future in the United Kingdom. If you found this information helpful, please consider giving this video a thumbs up and subscribing to the channel for more clear and direct guidance on UK immigration and nationality matters. Thank you for watching.